सब्सक्राइब कीजिए हमारे YouTube चैनल शॉर्ट एंड डिक्टेशन लीगल मैटर्स को और दबाइए इस बेल को ताकि आपको मिल सके हमारा वीडियो सबसे पहले और यह बिल्कुल फ्री है। रेडी स्टार्ट। In view of this pronouncement, there is no escape from the conclusion that an election petition can be summarily dismissed if it does not furnish cause of action in exercise of the powers under the Code of Civil Procedure. So also it emerges from the aforesaid decision that appropriate orders in exercise of powers under the Code of Civil Procedure can be passed if the mandatory requirements enjoined by Section 83 of the Act to incorporate the material facts in the election petition are not complied with. This court in Samant N. Balakrishna and another versus George Fernandez and others 1969 3 SAC 239 has expressed itself in no unclear terms that the omission of a single material fact would lead to an incomplete cause of action and that an election petition without the material facts relating to a corrupt practice is not an election petition at all. So also in Udhav Singh versus Madhav Rao Scindia 1977 1 SCC 511, the law has been enunciated that all the primary facts which must be proved by a party to establish a cause of action or his defense are material facts. In the context of a charge of corrupt practice, it would mean that the basic facts which constitute the ingredients of the particular corrupt practice alleged by the petitioner must be specified in order to succeed on the charge. Whether in an election petition a particular fact is material or not, and as such required to be pleaded, is dependent on the nature of the charge leveled and the circumstances of the case. All the facts which are essential to clothe the petition with complete cause of action must be pleaded, and failure to plead even a single material fact would amount to disobedience of the mandate of Section 83, Subclause 1, Subclause A. An election petition therefore can be and must be dismissed if it suffers from any such vice. The first ground of challenge must therefore fail. Learned counsel for the petitioner has next argued that in any event the powers to reject an election petition summarily under the provisions of the Code of Civil Procedure should not be exercised at the threshold. In substance, the argument is that the court must proceed with the trial, record the evidence, and only after the trial of the election petition is concluded that the powers under the Code of Civil Procedure for dealing appropriately with the defective petition which does not disclose cause of action should be exercised. With respect to the learned counsel, it is an argument which it is difficult to comprehend. The whole purpose of conferment of such powers is to ensure that a litigation which is meaningless and bound to prove abortive should not be permitted to occupy the time of the court and exercise the mind of the respondent. The sword of Damocles need not be kept hanging over his head unnecessarily without point or purpose. Even in an ordinary civil litigation, the court readily exercises the power to reject a plaint if it does not disclose any cause of action, or the power to direct the concerned party to strike out unnecessary, scandalous, frivolous, or vexatious parts of the pleadings. Stop.